Hello, good afternoon. This is Mr. Adv A S Khan from Pune, Maharashtra State, India. Now, I have come with a new video. At this point, where all our basic things about income tax are old, as I told you in my last video. Now, we will be going to discuss, or rather, I will give the facts of case of important judgments of Supreme Court from 1970 to 2020. But before that will be in the next video. But before that, we must have some good idea about uh, what is income tax dispute, what is judgment, what is order, and what is question of fact and what is question of law, and who are the appellate authorities as per Income Tax Act. These, these things one must remember before we touch our main topic, that is subject-wise income tax disputes and Supreme Court judgments on them right from 1970 to 2020. So let us start with income tax disputes. In, now we must know what is income tax dispute. What is income tax dispute? That this appeal takes birth from disputes only. When there is dispute, then only the concept of appeal comes into play. So we must know what is income tax dispute. Income tax dispute is a quarrel. Income tax dispute is a quarrel between taxpayer and income tax officer. This is that simple. It is a quarrel between what you call taxpayer and income tax officer. Or in other words, taxpayers disagreement. In other words, dispute means taxpayers disagreement with the tax liability the income tax officer has calculated for him. That is, taxpayer dispute means taxpayers disagreement with the income tax liability that income tax officer has calculated for him. So this way we can understand income tax dispute. Then how to solve this dispute? The Income Tax Act has given the solution, or rather appeal platforms, or they have got their own appeal system, and that we will learn now what is that appeal system. When income tax dispute is there, then assessee means taxpayer, he has to go to, this is the remedy for him when there is assessment order and which is not what you call favor. He is not happy with that assessee, taxpayer is not happy with that assessment order, then Income Tax Act has given him the solution or remedy. That remedy is like this: he should appeal. He should appeal to the appellate authorities. And which are the appellate authorities, or what is the remedy to solve the dispute, income tax dispute, or that is, I have told you, quarrel between taxpayer and income tax officer. So where to what you call solve this quarrel, or find solution for this dispute? So that dispute has to go to impartial entities. And who are the impartial entities? Impartial entities, I am referring to appellate entities. Impartial entities means appellate entities. And which are the appellate entities or impartial entities income tax has given in the act? The first is Commissioner Appeals. Second is Commissioner Revision. Third is Income Tax Appellate Tribunal. Fourth is High Court. And fifth is Supreme Court. These are the what you call appeal platform that income tax has given to the what you call aggrieved party. The dispute, not necessarily taxpayer is the aggrieved always. It is not like this. In many cases, revenue, they call it income tax department, they call it revenue. Sometimes income tax department also is aggrieved in some cases, or rather many cases they are also aggrieved. So they also can file appeal before this appellate tribunals, except that commissioner revision. They can go to tribunal, that is appellate tribunal, income tax appellate tribunal, or they can go to High Court, or they can go to Supreme Court. Who? These revenue people, income tax people. And assessee, the taxpayer, he, suppose he is not happy, he can also appeal. So this is the what you call platform, appeal platform income tax has given to both the parties. If if one of them is aggrieved or one of them is unhappy with the decisions of the lower court. So one thing we must remember, we can understand appeal to commissioner appeals. Appeal to commissioner appeals. We can also understand appeal to income tax appellate tribunal. We can also understand appeal to High Court. We can also understand appeal to Supreme Court. But one interesting provision in the Income Tax Act is like this. If suppose assessing officer or income tax officer, that assessing officer, income tax officer, when he gets the task of assessing tax liability, then he becomes his designation becomes assessing officer. That we have learned in the earlier video. So this assessing officer, after assessment, he fixes some tax liability for the taxpayer, and which tax liability the department notes this assessment, his assessment, and they find, they study that case, or they study that his assessment order where he has fixed what you call income tax liability for the assessee. That case they study, and if they find that assessing officer has not what you call done the work of assessment as per rules, he has not fixed the tax liability as per the rules. In other words, in simple words, he has what you call fixed the tax liability which is below the what you call below the proper tax liability, below the tax liability which should have been there, below that tax liability, legal tax liability, he has fixed the liability below the tax liability which should have been fixed by him. That way they find who income tax department. So if assessee is unhappy, he will go to tribunal, appellate tribunal. But what about these people, department people? Their own man is doing the assessment work. Their own man is calculating the income tax liability for the taxpayer. And suppose and this department feels he has not calculated properly. That tax liability should have been more, but he has calculated less. In this way, or something wrong he has done, he has allowed the expenditure when it should not have been allowed. Like there are so many reasons which make this income tax department unhappy with the work of assessing officer. So where they will appeal? They cannot go in appeal to his own man, assessing officer. So to tackle this position, to what you call do some correcting work, or to have the proper tax liability from the taxpayer, what they do in such cases, they internally they first find out that this man has done mistake, assessing officer in this particular case. Then they ask the what you call commissioner to revise this assessment, because this his that assessing officer's income tax liability, the way he has worked the liability is wrong, that he has done wrong work and that liability should have been more, but he has fixed the liability less. So that way they ask the commissioner revision to revise the assessment, and he revises the assessment. So this is the remedy to the income tax department when their own man passes the order which is against them, which is against revenue. Against them means, against revenue means against income tax department, which is against them. That means he has fixed less tax liability for taxpayer, and they find this error, they find it, and they have got good reason to revise the assessments. Then they go for revision of assessment internally through commissioner revision. It is like this. So these are the appeal platform. The Income Tax Act gives the what you call appeal system, and that appeal system provides these things: commissioner appeal, then income tax appellate tribunal, then what you call high court, and then Supreme Court. These are the appellate authorities where assessee or revenue, that is income tax department, can go for getting justice to them. Okay. Now, what is the procedure they follow? These courts, that is appellate tribunal, then your assessing officer, then your commissioner appeals, then income tax appellate tribunal, and your commissioner revision, then high court and Supreme Court. They have got one common principle to follow. And that common principle is principle of natural justice. That procedure for what you call appeal. Wherever there is appeal, then and what you call, then the court before which this dispute has come for decision, they have to follow one fundamental or universal rule of natural justice. And what is that universal rule of natural justice? That is, that court has to give, that court has to hear the what you call taxpayer who has come before them with complaint. Income tax department has not fixed my tax liability as per rule. They have fixed more, which I don't accept. These are my reason for not acceptance. So that way he submits his case to what you call appellate authority, maybe tribunal, maybe high court, or maybe Supreme Court. So then that court has to, that is appellate authority or your high court or Supreme Court, has to give the opportunity, they call it opportunity, that these courts, appellate authority, high court or Supreme Court, has to listen to him. That is very fundamental. If something is decided, if the court decides without giving him chance, without listening to him, what he has to say against the other party, if they don't do this, don't follow this procedure, when they don't ask the party, aggrieved party, to tell what you want to say without asking him, if they decide the case, that will be thrown out. That will be thrown out. It is unconstitutional. It is illegal. So this is the rule of principle of natural justice. It is followed universally, not in India, in all the countries of the world, in the respective judiciary, they follow this golden rule of principle of natural justice, to listen to the party who is aggrieved, and then ask the other parties also, listen to both the parties, then take the decision in the matter. That is the this is the procedure. And another procedure is there in High Court, your when appeal is before Commissioner Appeals, or when appeal is before your income tax appellate tribunal, then that appeal should go online. That means that aggrieved party, this taxpayer has to use technology, has to use the what you call income tax website to file the appeal. So that is use of technology is must. No physical meeting with the what you call commissioner appeals or that court, that is appellate tribunal. No personal meeting, no. They call, okay, but you on your own you cannot go there and meet personally. So that is strictly that is disallowed now. Yeah, everything through technology or through website of the income tax department. That aggrieved party has to file appeal online. That means through, by use of technology, and by use of technology means by logging in or connecting to your account to the website of the income tax department, and there you get everything there, form, appeal form, how to submit the appeal, how to send the reply, how to send the document, everything is there inside. So that way use of technology is must. That is web-based appeal. We may call it web-based appeal, that is. But income tax department people use the word faceless assessment, faceless appeal system, faceless appeal system. That way they call it technically. Anyhow, this is the procedure they follow. All these judicial authorities, they follow this procedure. Give the hearing to both the parties. Then, as far as technological feasible or possible, then particularly your what you call commissioner appeals and appellate tribunal, income tax appellate tribunal, this one has to file appeal online by use of technology, or by through website of income tax department. So these authorities and their procedure I have explained you. Then what are the powers? You go, we must also know their powers. Powers of the commissioner appeals, powers of the tribunal, powers of the High Court, and powers of the Supreme Court. So powers, because dispute is about income tax liability. One party says income tax liability is fixed more. Other party says no, we have revenue says we have correctly fixed, as per rule we have correctly fixed the income tax liability. So these powers also move around these questions only, this more or less tax liability. So these powers of these judicial authorities, that is commissioner appeals, then your appellate tribunal or High Court or Supreme Court, what they do, they confirm the tax liability. They may confirm the tax liability. It depends on lot of things. This is a lengthy procedure. All principles, everything is involved there. This is not that simple. You what you call tell something, some question, and they will immediately give answer. It is not like this hearing and that proceeding. They call it proceeding. Proceeding means this is all procedure. Filing of appeal, then sending of documents, and then hearing, and then delay, and so many other things are there. Then again adjournment and all these things. So this proceeding, they call it proceeding. So what happened? These powers are around this only, tax liability only. So these authorities, judicial authorities, what they do, judicial courts, income tax, as far as income tax is concerned, they confirm the tax liability. They may confirm the tax liability or they may cancel the tax liability. See the powers, confirm or cancel, both very important powers. Then they may reduce the tax liability. This is also important power. And they may increase the tax liability. This is also important. All powers are important. So that is why these courts, Commissioner Appeals, Appellate Tribunal, High Court, Supreme Court, that is why they are powerful people. They are powerful people. Why they are powerful? Because they can do this much thing. They can do all these powerful things. That is, they may confirm the tax liability. They may cancel the tax liability. They may increase the tax liability. They may reduce the tax liability. So these are their powers. Now we'll also side by side we will also try to understand some terms, some terms related to this appeal system and decision and all these things. So first such thing related things to appeal is judge. Who is judge? Who is called judge? A judge is a person who is the presiding officer of a civil court. That is what our Civil Procedure Code 1908, Civil Procedure Code 1908, Section 2, it defines who is judge. Judge means a person who is presiding officer of a civil court. And what is judgment? What is judgment? Judgment is nothing but the statement of grounds for order. When judge decides the disputes or when he finds the answer to the question given to him, then he gives the decision, and simply he doesn't give the decision, he gives the reasons also. In other way, he gives the grounds also. In a statement, formal statement, he gives the grounds for his decision or for order. That becomes judgment. That is called judgment. Then what is order? Order is also simple thing. Order means a decision of judge, a decision of a judge. When he writes the decision and sign it, that becomes his order. When he writes the decision, he reduces his decision in writing and sign it. That becomes order, his order. This is the judgment or order. That is all given in CPC. You will find that in Section 2. Then further, question of fact and question of law. These are all related to our income tax appeal system. This, whatever I am talking of, these terms or phrases, that is question of fact and question of law. These are the things they go before these judicial officers. This commissioner appeals, your income tax, tribunal, appellate tribunal, High Court, Supreme Court. So this question of fact and question of law. Question of fact is simple, that this commissioner appeals or your income tax appellate tribunal, they are masters. They are masters in fact finding. That is why sometimes, or rather many times, this income tax appellate tribunal is called fact finding entity. Fact finding entity. So whatever they have found out in the case, again this work of finding fact, that High Court will never take up. High Court, Supreme Court, they will never retake up this work again. They will not take up this work again. Fact finding work they will not take. They rely only on the finding, the tribunals, appellate tribunals, they rely or depend on the finding of the appellate tribunal, income tax appellate tribunal. So they themselves will never again go to what you call go to fact finding work. Okay, but they can go in exceptional situation when some serious omission is there. They have not given chance or opportunity, or they have not called the parties, they have not heard the parties, and they have given the decision. If this thing is then aggrieved party, or aggrieved party proves this thing to the High Court, then they may intervene and they may pass the necessary orders. Okay, so this is the what you call uh, 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 what you call uh, uh, the what you call procedure we have learned, that is online procedure, then rule principle of natural justice, and what you call uh, there's uh, some phrases, some terms, that is judgment and order, and then question of fact, that is normally things come before what you call your commissioner appeals. So naturally there and then dispute come before commissioner appeals and dispute before income tax appellate tribunal. They naturally, the nature of dispute is about facts, whether this is fact or not, what he says is correct or not, this is fact. So this type of fact, question of facts, that is always normally comes before these two what you call authorities, judicial authorities, that commissioner appeals and this appellate tribunal. Appellate tribunal is civil court. Remember this. Appellate tribunal, income tax appellate tribunal is a civil court. This is very important. And commissioner appeal is not civil court. It is appellate tribunal is civil court, and the president of the income tax appellate tribunal is a high court judge, sitting high court judge, or retired high court judge. So see the what you call weight of this tribunal. This is tribunal. Tribunal is civil court, and this is headed by sitting high court judge or a retired high court judge. So they have got lot of weight. Income tax appellate tribunal. Though that that entity is fact finding entity, but it has got lot of weight, and its finding is what you call all the higher courts, they depend on the finding of income tax appellate tribunal. So they face this. Normally commissioner appeals and income tax appellate tribunal, they face the question of fact always, or many cases they face the question of fact. And this, what is question of fact? Whether something is there or not, then they have to call the parties, they call the witnesses, or they call the documents, and they verify. One simple example is like this. There is one provision in the Income Tax Act, when you have got agricultural land, and then that agriculture, you are owner of that agricultural land, and when you sell that agricultural land and you get crores of rupees. Nowadays we have to talk in terms of crores only, nothing in lakhs. So crores of rupees you get, then you have to pay the income tax in the form of capital gain, income tax on sale of your agriculture land. And normally, I'm sorry, that one has to pay the tax if his land, agriculture land, is located in the corporation limit. If it is located in the corporation limit, then one has to pay the tax. If you have got property in agricultural land, though it is what you call, you are doing agriculture activity, but because it is located in the corporation limit, and if you sell and you get crores of rupees, on that you have to pay the income tax in the form of tax on capital gain, like this. But if it is not located in the corporation limits, municipal corporation limit, it is not, but it is situated beyond corporation or municipal municipal municipality limits, then that is, they call it agricultural land, and if owner of that agricultural land sells the land and he gets a lot of crores of rupees, then that is not taxable. So then there are agricultural lands, their question of fact arises whether that land is within the corporation limits or outside the corporation limits. So naturally the party who is the owner of that agricultural land, he maintains or he says that this my land is agricultural land and not located in the corporation limits, but it is located beyond the corporation limits. That way he takes the stand. And revenue, that is income tax department, say no, this what you call the land, what he says, agricultural land located not in within corporation. As per our record or as per our proof we are giving, we have submitted you, it is very much within the corporation limits. So he is responsible to pay the tax when for what is capital gain. Like this, they argue who this revenue, the income tax department. So this thing is a question of fact, whether that particular land is agricultural land, whether it is situated beyond corporation limit or whether it is located within the corporation limit. That is the not question of law, it is question of fact. So they have to decide. Then who, this Commissioner of Appeals or Income Tax Appellate Tribunal, they decide, they take into account or they study or they examine the proof, evidence submitted by both the parties in support of their argument, and they may also refer the case, who this Commissioner Appeals and Appellate Tribunal, to the Survey of India or some other appropriate or relevant proper authority who can authenticatively and with what you call with 100% sure as far as government sources are concerned, where these records of distance, record of corporation limits are in the Survey of India or other relevant things they take into account, and they decide the question of fact. In any way, yes, it is within the corporation limit or it is beyond the corporation limit. That way they decide who these are Commissioner Appeals or what you call Appellate Tribunal. So they decide the what you call question of fact. So this is question of fact. What I wanted to tell you, what is question of fact. I have given one example, agriculture. Then there is question of law. This is also question of law. Normally, question of law goes before High Court and Supreme Court. These lower courts, that is Commissioner Appeals and your Income Tax Appellate Tribunal, they hardly touch this question. They collect the facts only. Who? Appellate Tribunal, Commissioner Appeals. Particularly Appellate Tribunal, fact-finding entity. So whenever there is the case involves or there is a case has got the some technical issue or technical problem or legal problem, they cannot interpret or understand the particular provision of law or section, then this is called question of law. And that, so this what you call tribunal, on the request of the what you call assessee or taxpayer, may refer that case to High Court for decision, or this taxpayer in appeal, if he says who that Appellate Tribunal says there is no question of law here, and as per facts you have decided your case, you have to, we confirm the tax liability, or this way. If this is the way they decide, that Appellate Tribunal, then this assessee, taxpayer will go in appeal to High Court, and there High Court will frame the question of law. There will, again there will be two parties. this taxpayer who is unhappy with the decision of the appellate tribunal, and then revenue, the notice will go to revenue also. The party has come for with this complaint against you, against your tax liability, etc. So on getting the notice, revenue, that is income tax department people, they will also prepare their case, arguments, documents, everything, and both will quarrel at High Court, this whatever. So there High Court will not go into the facts of the case. What they will do, they will frame the question of law. What is the question of law here in this case? What for this case has come to us? If they find there is no question of law, they will simply send back the case to tribunal, or they dismiss the appeal. There is no question of law. But when they find that this case has got question of law to be answered by us, then they will admit the appeal, and they, after framing the question, they will decide that question, or they will find the answer for that question, and they will give the decision. They will give the supporting reasons, supporting justification, supporting grounds for their decision. Like this they will do. Who? High Court and Supreme Court, both. They, without question, if suppose High Court, High Court to cut short the work, it doesn't frame the question of law, or they don't make the question of law, and neither they make the question of law, and don't give hearing to the parties, and they decide, and somebody goes to appeal and tells this thing, this lower High Court has done like this, no hearing given to the parties, then there is no framing of question of law. So Supreme Court will definitely come to the help of the party who has come to them with the proof that High Court has done or has gone against the procedure. So they will they will quash, or they will say no to the High Court order. They will send back the case, and they will ask the High Court to give hearing to this, listen to them, listen to this party, and frame the question of law and answer that question of law. Like this they will say, procedure is procedure fixed. So they don't have their own liberty to cut short the procedure and do the things they want to do. Like this, this is not accepted. Supreme Court doesn't accept this way of working, and very strict, and it is no doubt waste of time for all the people. Anyhow, so this is the question of fact and question of law. This question of fact, as it goes before these two authorities, Commissioner Appeals and Appellate Tribunal, and question of law normally goes to High Court and Supreme Court. And High Court and Supreme Court, without question of law, they don't entertain, or they don't accept the appeal, and they don't do anything. They simply return back for framing the question of law. So question of law, this question of law, after framing it, this High Court, first we must know what is question of law. Question of law involves interpretation of section or provision of income tax or section of income tax. Question of law, it asks the High Court or Supreme Court to interpret or say us what is the meaning, what we have to understand by this section or provisions. Like this they put before the High Court and Supreme Court if appeal is gone to Supreme Court. But normally High Court they ask this question, what is the import? Import means meaning or interpretation of this provision or this section. Like this they ask High Court, and High Court has framed the question, and it answers the what you call, it answered that question. And that High Court is expert in the sense that judge is expert in interpretation. He knows the what you call principles of interpretation. That is another big subject. Principles of interpretation of statute. So this is interpretations of law. This very important field, and these people, the High Court judges, they are expert. High Court judges and Supreme Court judges, they are expert in interpretation of rules and provisions of Income Tax Act and sections of Income Tax Act. So this question of law, for example, this repairs a businessman, he has got building, factory building and all these things. So naturally, sometimes repair is necessary. So normally small repairs, repairs costing some few thousands of rupees or few lakhs of rupees, say they call it business expenditure or business expenses on the debit side of the profit and loss account. But these revenue people, the income tax department people, sometimes they object. Or assessing officer, when he assesses or he checks the what you call your income tax return and your profit and loss account. So he finds that these expenses is not current repair or repair. It is capital expenditure. It is capital expenditure. That means that expenditure should what you call merge into the whatever amount of that asset is there. Some machinery is there. So these expenses incurred for repair should go into that cost of machinery, purchase cost of that machinery. If it is capital, not business. So repair, there are always headache is there for courts whether repair expenses. One thing you must remember, amount is not the what you call factor to take into account for deciding whether this repair is business expenditure or capital expenditure. When expenditure is more, so you will say capital expenditure. It is not like this. It has got another what you call principle for decision, for deciding, that I will not discuss here because it will unnecessarily become lengthy. So question of fact, it is about this, whether suppose some businessman has claimed repairs as current expenses and shown in the profit and loss on the debit side. So the tax people, they say it is not revenue expenditure, it is capital expenditure. Go, you should not take the benefit. If department allows that expenditure as repair expenditure as revenue expenditure to be shown in what you call in profit or loss account debit side, then naturally tax liability income will be reduced and tax liability accordingly will go down, and there will be less revenue to the department. So that is why they object. These revenue people, income tax people, they object to the, look at the repair expenses also, whether revenue or capital. So when there is such question, who will decide? High Court will decide, whether, or Supreme Court will decide, because it is a question of law, whether it is revenue or capital. Then they have got their own interpretations rules, and by using those principles of interpretations of law, they will find the answer to the question, whether this is capital or not capital, or revenue or not revenue. Like this they will decide and give the reasons also, supporting judgments also. That way they give the judgments and pass the order accordingly. So this is a question of fact. Question of law. I have given the example. So question of fact always before this Commissioner Appeal and Appellate Tribunal. Question of law normally before High Court and Supreme Court. These are two. And then you want to refer to, I think this is last thing I am just sharing with you. Then you want to find the judgment of Supreme Court. You want to find the judgment of Supreme Court, where you will get. So ITR is there in the market, but ITR is very costly, and this is always in demand everywhere. If you join some library, they have to pay a heavy fee, deposit, security deposit or something. Then only they allow, they make you member, and then you can use. You go there, then say that this copy is already under use, so wait for some 15 days. So if matter is urgent, where you will refer, where you will go. You cannot, how long you will invest, go on investing, purchasing from the open market. So for that, you remember this thing, what I am telling now. So there is website of Supreme Court, and on that website you will get all the judgments given by the Supreme Court free of charge by sitting in your home or in your office under the fan. You just use your computer, go to Supreme Court website and get the judgment, read the judgment and get the information you want. You take that from that judgment. And the address of that Supreme Court website is like this: www.sci.gov.in www.sci.gov.in. So this is the website address of the Supreme Court of India. So you can use this what you call address and have the necessary judgment before you, and read the judgment, take the information you want, and sort out the case matter. So I think this is beginning we have made. Then next video we will start our judgment. The judgment patterns will be like this only. We will take some, though this what I am telling, what I have titled, the title of my topic is subject-wise Supreme Court judgments and subject-wise income tax disputes and Supreme Court judgments on them right from 1970 to 2020. So this is my what you call title of this video. So though this is right from 1970 to 2020, 50 years, what will subject, if now we will be taking first salary subject, because there are five to six types of heads of income, that is salary, income from house property, income from business, then income from sale of property, then income from other sources. Five sources are there, five heads of income are there. So I have prepared, or I have collected the judgments on these five subjects. So naturally we will start first salary. From salary we will start, but we will not 50 years each and every judgment we will not take. Very landmark, or they say landmark, very important, interesting judgments will briefly we will discuss. That we will proceed. We will take some few judgments, important, interesting judgments from each head of income, and we will finish up this our series of lectures. Okay, so we will meet next time. Okay, thank you very much.